Everyone. I'd like to welcome you to the June 17th Livingston County Electoral Board hearing. Please remember when you're talking, speak into the microphone and state your name prior to speaking and only one person at a time. This would be greatly appreciated by the court reporter as well as the audience. So I think John, you had microphones for them then to, okay, yes, to make sure you speak into those. Okay. Yep, there's a center one on the podium then too. Okay. We'll now have roll call. Treasurer Nikki Meyer.
Here.
Circuit Court Clerk Jackie Gregson.
Here.
County Clerk Christy Mashing, present. We have a quorum and will proceed with the meeting. Also present and assisting the board is Stephen D. Mart, attorney with Ansel Glink Law Firm. Sandra Reinders is the court reporter. And thank you for coming. Before we begin, I would like to note that the approval of agenda was omitted from the distributed agenda for this June 17th meeting. I will now entertain a motion to approve the agenda. Is there a motion to approve the agenda?
I'll approve the agenda.
And is there a second?
I'll second.
The motion to approve the amended agenda has a second. Those in favor respond with ayes. All those in favor?
Aye.
Aye. The amended agenda is approved. Is there a motion to approve the June 8th, 2026 meeting minutes?
I'll approve that motion as well.
Okay. Nikki and Jackie?
And I'll second.
Okay. The motion to approve the agenda has a second. Those in favor respond with ayes.
Aye.
All vote yes. The agenda is approved. At this time, I will call the case before us. The objection to nomination papers of independent candidate for the office of State's Attorney of Livingston County, the general election to occur November 3rd, 2026 general election. And I will call the case. David Rice, petitioner, objector, versus Anthony Tomkowitz, respondent, candidate. I would also note that we had, prior to this meeting, an appearance as counsel was filed by William J. Gerber for respondent, objector, David Rice. The next item we'll get into is the procedural matters, pre-hearing motions. There were 4 preliminary or pre-hearing motions filed. The first one was Dave Rice. The plaintiff motioned to disqualify and remove opposing counsel Robert Falmer, and that was filed on June 10th. The second one was filed by Ottelson and Falmer. Candidates motion to strike and dismiss objector's petition, dismissed due to a number of reasons, insufficient in law and fact, and June 10th is when they filed that. The next one was William Gerber, the objector's response to candidate's motion to strike and dismiss objector's petition. That was filed June 14th. And then we had the candidate's reply in further support of his motion to strike and dismiss objector's petition. That was filed by Ottelson and Falmer, June 16th of 26. And at this time, we'll defer to Steve, please.
Are there any other procedural matters that need to be addressed at this time? The next item on the agenda is arguments on the motions.
I do have one more procedural issue. If I can approach.
Mr. Aldelson?
Yes, thank you. Last night, co-counsel Mr. Fulmer reached out to me to tender me a packet submitted by a prospective candidate to be slated by the Republican Party. In that packet, there is a letter of support for that person named Mary Lawson. That letter of support is signed by Jacqueline Gregson. I want to tender that letter. I normally would file a motion, but this was late last night when I got the material. The nature of my motion and my request is that the circuit court clerk recuse herself from participating because of the obvious bias, which is her own bias and her own opinions, which is just fine. The precinct committee persons, including Mr. Fulmer, received the material, more material than I've given you. It was a background on the other candidate asking for slating for state's attorney for the November election. Just as an aside, the party cannot slate anymore. That time has passed, but that's for another day and another argument. In the materials given to the committee persons, there is this letter of support that I have passed out to council and to the electoral board, whereby the circuit court clerk has endorsed Mary Lawson, which again is her right. Any litigant, whether criminal or civil, is entitled, or before an administrative board, is entitled to a fair and impartial hearing before unbiased judges or board members. Based on the obvious bias, in order not to taint these hearings, I am requesting that the circuit court clerk recuse herself, step aside, and allow this matter to proceed. We certainly can proceed with two board members. That's quorum. I'm ready to proceed today. I believe counsel for the objectors ready to proceed, but I think this is very important to raise at this time, and I do it for two reasons. One, to alert the whole board, and two, to preserve it in case there's court proceedings after that.
Thank you. Mr. Gerber, do you have a response?
Do you want me to come up here as a
Just
microphone?
use the center mic's fine.
I would just ask the board to note the date specifically on this letter of April 21st of 26 in relation to the notations. Said date is prior to the filing of any of these documentation, or any of this documentation with the board. It makes no reference one way or another as to any opinions as to Mr. Tomkowitz in any fashion. I think a mere letter in support of a candidate in and of itself does not provide any bias one way or another in respect to a relative ruling on a substantive motion being filed in this case. Further, I would note, you have a motion filed by Mr. Rice prior to my involvement, setting forth very, very similar grounds associated with Mr. Fulmer, who's represented him. So they appear to have an objection to the motion filed by Mr. Rice to recuse an attorney who's doing the same thing. However, provide a letter here attempting to then request the board do exactly what they're refusing to do. So I find the arguments invalid, without merit, and I request the request be denied.
Rolison?
Just a short reply. The last sentence of the first paragraph of the letter, I would like to express my strong support for her application as state's attorney. That's number one. Number two, Mr. Fulmer, who is co-counsel, is a lawyer. He's not deciding anything in this case. He's a lawyer representing a client. That's why neither Mr. Fulmer or I answered Mr. Rice's motion to disqualify an attorney. It's pretty far out there, and wasn't worth the response, to be quite frank. So this letter, and again, I want to stress, Ms. Gregson has the absolute right to be for whoever she wants to be, but the 3 members of the board are now judges in this case, with the ultimate decision whether the people of Livingston County will have a choice or not. So in order not to taint these hearings, because after these hearings, whoever loses probably will go up to the circuit court, I don't want to see this being an issue, and we can clear this issue up very quickly by having the circuit court clerk recuse herself, or the board do a motion to disqualify.
Mr. Odelson, can you address whether or not a replacement is required under the statute? I seem to recall that if one member is disqualified for any reason, then there's a certain succession, and if she's disqualified, would the circuit court or the presiding judge have to make a replacement appointment?
Not yet. The next replacement is the sheriff. And then after the sheriff, if the board so chooses, they can go to the circuit court and have the chief judge do a replacement. You're absolutely correct. Or the board can proceed with 2 members. That's a quorum. I've been before many boards where the 3rd member didn't show up and they just proceeded, because these are expedited affairs.
Right.
So yes, you have a choice.
Right. Mr. Gerber?
In the event the board was to subsequently rule relative to recusal, given the sheriff is the next in line, you're going to have the same issue associated with Mr. Baum based upon his endorsement of Mr. Tomkowitz. So we're going to have to go to the court in relation to the appointment of another individual. So, however, the court or the board wishes to do this, we're going to have the same problem. We would raise the same objection based upon the arguments today. So we will need to take it to the court to find a replacement.
All right.
Just so you're aware.
Well, anticipating an objection to the sheriff, then it looks like if the motion is granted, we're probably requesting a replacement from the judge. We want to discuss among ourselves the motion that's pending. I would say, in advising the board, I would say that it's probably important to avoid any appearance of any kind of impropriety, so that there's not an issue should this case go up on appeal regarding your participation. So my recommendation would be to recuse yourself, and we would then move for an appointment, anticipating the objection to the sheriff.
I'll go ahead and recuse on advice of counsel.
Mr. Olson?
Thank you. The board does have the option to proceed with the majority that's here, or, as you said, they could go back to circuit court and ask the judge to appoint the 3rd member. I just want to make sure they know their option, and we're both ready, and the election machinery is in gear. Just it would be I would prefer going ahead with the 2 members, but again, this is a board decision, not mine. Thank you.
It is the board's decision whether you want to move forward today with just 2 members. We do have a court reporter present, so if a 3rd member were appointed between today and when a decision is made on the motions, that member could get up to speed and participate in that decision. And that would be my recommendation, since everyone's here, that we go ahead and have arguments and take the matters under advisement, seek appointment of a third member, and then at some future date, make a decision on the motions. To appoint a member?
Yes, I mean, just.
Yeah, I don't think it would take very long. You just appoint a citizen member of the board. Be up to the judge and his availability and how soon that can get done. I would imagine within a week.
I guess associated with what you're requesting be done, are you requesting arguments be had, the person get appointed, review the transcripts, the three members make a decision as to the motion as a whole?
Yes.
Okay, all right, I just want to clarify, there will be 3 votes associated with the motion.
That was my recommendation.
Okay, all right, thank you.
You know, we don't want to, sometimes having only 2 can create a problem. So an odd number is always better. So, based on the discussion, the board will seek a third appointment from the judge, and we'll move forward today with arguments on the motions, since we're all here. As far as process, Mr. Oldelson filed the motion to dismiss, but Mr. Rice also filed a motion to have Mr. Fulmer removed from the matter. Is there any preference among you two as to who goes first?
Relative to the recusal motion, I'm not going to address that at this time. I think that'll be a separate related issue based upon what the board does relative to the motion to dismiss itself. So
Okay.
I'll reserve that at this time.
All right. Mr. Oldelson.
Thank you, Mayor. Please, the board. I'm sorry I got off on that note, and that's always a difficult thing to do, but as your counsel said, we want to keep the record as clean as possible for further review. I'm just going to be brief because we weren't brief in our motions, and you have our motions, and hopefully you've read the motions, and now you have counsel also to help you with that. I just want to hit some highlights in regards to this case. The primary was March 17th. May 15th is the appointment of the new state's attorney. May 26th is the last day to file petitions to be on the ballot as an independent candidate for the November election. June 1st was the last day to fill a vacancy and nomination by a political party. And again, that's really not an issue here. I have a little feeling that may be an issue down the road for someone else, but the time to fill the vacancy of the political party is past. Thus, we have a very unique situation of a vacancy in office occurring after the primary. The primary, where the office was not on the ballot, because you still had a state's attorney, and the state's attorney's term is not up for another 2.5 years. A very unique situation. As you all know, the county board appointed Mr. Tomkowitz as state's attorney. He had only 10 days over a holiday weekend to gather signatures. And whether the number is 837 signatures or 232 signatures, as I suggest, is a monumental task not contemplated by the law. The law is very hard and fast as to when you can get your petition signed. So what is this case all about? It's really all about ballot access. It's about voters' rights. It's about candidates' rights. It is, as our Constitution teaches us, about freedom of speech, due process of the laws, equal protection of the laws, and fair elections, especially with all the rhetoric in the last decade about fair elections. Here is another example of perhaps this not being a fair election because of one candidate perhaps being removed. This is a case about a candidate obtaining ballot access after he showed what we call in the law a modicum of support. That's a term you really only hear in the law and as applied to petition cases. The law defines a modicum of support as minimal appeal to the voters. That's the definition. To outline the case law from the United States Supreme Court, the Illinois Supreme Court, our appellate courts that abide by the golden rule in ballot access cases is that ballot access is a substantial right and not to be lightly denied. That is the quote we read over and over again in all of the ballot access cases. Through my 50 years in practicing election law, that is always the reoccurring theme. A person has a constitutional right to ballot access if they show some support by the voters. Well, the state's attorney filed close to 900 names, I think 889, who asked that he be put on the ballot. That is certainly more than a modicum of support. Our courts have always held that they tread cautiously when asked to restrict voters' rights to nominate and vote for the candidates of their choice. Our laws are to be liberally construed when it comes to ballot access, and courts always favor ballot access. It's very telling, I think, that the objector chose not to answer or otherwise contest all the arguments I made in regards to ballot access. Why? Because there is no argument. That's why our democracy was formed, and that's how we live it today. Our country was built on people's rights to vote and candidates' rights to run for office. This case is a perfect example of trying to avoid the will of the people to be able to vote for the candidate of their choice. I cite many ballot access cases in my motion and in my arguments. All of them, and many more, hold that ballot access is a right after showing some minimal support. And that's exactly what we have here. I could talk about ballot access for quite a long time, but I'll leave it at that along with my motion that I filed. The essence of my motion to strike the objection is the objector's failure to comply with Section 10-8 of the Election Code. 10-8 of the Election Code gives us the guide as to how a person can object to a candidacy. Unlike the ballot access cases, all of the legal cases from the United States Supreme Court on down say you must comply strictly to the mandatory obligations of the objector's petition in Section 10-8. There's no wiggle. You must do what that section says. Why? Because we have ballot access and people's right to vote at stake. There's only 5 things you have to do when you're an objector. You have to state your name. And by the way, the statute says shall. And as you may know, shall means mandatory, you shall. It doesn't say may, it says you shall. You shall state the objector's name. You shall state the objector's residence address. You shall state fully the nature of the objections to the nomination papers. You shall state what relief you're requesting of the electoral board, and you shall state the interests of the objector. 5 things. The objector in this case complied with 4 of those items. He did not state an interest. Now, you're going to hear in a minute able counsel saying that he did state an interest because you can look to where he said he's a registered voter. You can look to where he said there's problems with the petitions, and you can look to where he said you should take them off the ballot. You can't point to anything in the objector's petition where the objector cites what his interest is. He doesn't have to have a particular interest, whether it be he's running against the candidate, whether he doesn't like the candidate, whether he's a different political party, whether he just doesn't like the way the candidate looks. He doesn't have to say, there is no precise answer in the law as to what the interest has to be, but you have to have an interest. I know it sounds a little bit menial as compared to the other requirements, but that's the law. He tries to piece together in the response to my motion an interest of the objector. And the objector was fairly careful in specifying 4 of the 5 items in his objector's petition. And we candidly admit he stated the 4 items that he had to state. It is not the electoral board's job to imply or think about what his interest may or may not be. He has to state his interest. Now, in general, those of us who practice election law, we have a standard statement. The objector is a citizen desirous of seeing the election laws upheld. Those of us who do this on a regular basis, that's what we use, because that's all you have to use. But we use that because the statute says you shall state an interest. If you do not state your interest, the motion to strike and dismiss should be granted, and it ends the case, because it's a mandatory requirement. I'll have a little bit more to say about that on my reply, but I want to stress that, as menial as it may sound, that this objector didn't state his interest. In my reply, I talk about the fact if he didn't state his name, you'd have no problem granting my motion. If he didn't state his address, you'd have no problem. If he didn't state what he was objecting to, you wouldn't have a problem striking the objector's petition. And you should have no problem in striking the objector's petition in favor of ballot access, in favor of allowing the people to exercise their right to nominate and to vote, because he did not specify an interest. I then move to another section in regards to the number of signatures required. In this case, the number that was used, I think, was 837. And it was based off of the general election when there were, I believe, 16,736 ballots cast. Now, that's generally what we do. But this is a unique situation. And in the situation here in Livingston County, you elect precinct committee persons at the March primary, which is a regular election as defined by the election code. You elect them. That's the election where the precinct committeemen are elected. You also have a very unique circumstance whereby the county clerk, the county treasurer, the sheriff, and members of the county board in districts 2 and 3 have no Democratic opposition. They were nominated at the primary election, and for all, I can't think of a situation where they would not be elected in November since they have no opposition. Therefore, I submit, because of the unique circumstance, and I talk about it in my motion, similar to the COVID situation, where we had unique circumstances, and you had a federal judge reduce the signature requirements in the COVID year by 90%. So if you needed 100 signatures, all you needed was 10 signatures to get on the ballot. And I cite the case whereby the court recognized, because of the unique circumstance, it was unfair to ask people to go out and get petitions signed. And everybody who wanted to gain ballot access did, because of the unique circumstances. You have unique circumstances here whereby the state's attorney only had 10 days to get petitions signed. Now, normally, as the electoral board members know, because you've run for office, you have 90 days prior to the date you have to file your petitions to gather your signatures. Now, 837 signatures in 90 days, not so bad. 837 signatures in 10 days over a holiday weekend, that's a heavy lift. But the state's attorney did it. He filed almost 900. I think, that you should take the ballots cast in the primary election of March 17th, where there were 5,630 ballots cast, where you elected precinct committee persons, and where you basically elected county officers because there's no opposition in November. And because of the unique situation here in Livingston County, with having a state's attorney resign to take a judgeship after the primary, and the state's attorney only having 10 days, I think this is a case similar to the COVID situation, where the regular election you look to is the March 17th primary for this office. The other argument, I should just touch on this too, there's an argument about dual circulation. And actually, that is in my section about the constitutionality of these two articles of the election code as it's applied to the state's attorney and to this race. Under section 10-4 of the election code, people who circulate petitions for a political party in the primary are not allowed to circulate petitions for independents or new political parties for the general election. But what happened here is there was no primary for state's attorney because there was a state's attorney serving out his term. So the people, the Republicans who circulated for the March primary, circulated for other candidates, not for the state's attorney's office, because there was no state's attorney's office to circulate for. So the 10-4, which is the provision of the election code, which says you can't circulate for a political party and then for an independent, is not constitutional as applied to the state's attorney in this case because of the unique circumstances. One of the quotes I cited at page 14 of my motion from a very recent Supreme Court case called Elam, E-L-A-M versus Municipal Officers Electoral Board, is very telling. And I don't like to read quotes, but I have to read this one because it directly applies. The policy reasons for the dual circulator prohibition become more evident in situations where a circulator solicits signatures for both a party candidate in the primary and an independent candidate in the general election, both of whom will challenge one another for the same elected office in the general election. Section 10-4 clearly prohibits situations as this, as it would undoubtedly cause voter confusion. That's the reason for the dual circulation prohibition. You don't have that here. How can there be any confusion? There was no candidate for state's attorney in the primary. So those allegations pertaining to circulators who may have circulated for other Republican candidates and then chose to circulate for your state's attorney do not apply to this situation. There could be no voter confusion. Starting with on page 15 of my motion, starting with the case called Cusper versus Bonticus, a 1973 case, and going through Sperling versus County Officers Electoral Board, McGuire versus Nogaj, Norman versus Reed, and Hosfeld versus Illinois State Board of Elections. You have a case from the United States Supreme Court, from the Illinois Supreme Court, and one case from the federal court, and one case from the Illinois Appellate Court. I picked those 4 cases, not because I argued 3 of them successfully, but because they all stand for the same proposition. The old ban on candidate party switching, which used to be a 23-month rule, is gone. It's over. These cases said no more. And how is that applicable to our case? Someone who circulated in the Republican primary is free to circulate for an independent in this situation and to vote for an independent in this situation, or to vote in the November election for whomever they want. The old 23-month ban on party switching, where you had to actually sit out a primary before you could switch parties, is gone. And these cases stand directly for that point, as I cited at page 15 of my brief. So the unconstitutional allegations I've made, I certainly know, because I've represented a lot of electoral boards in my time, you cannot decide whether a statute is unconstitutional or not. That's for the courts to do. But you can decide in regards to ballot access, in regards to due process of law, in regards to equal protection of the law, that these sections that the objector's using in regards to dual circulation, in regards to the amount of signatures needed, which is 10-3, do not apply in this case. This is a very unique case. Mr. Tomkowitz did a yeoman's job, he and his people, in garnering 889 signatures in 10 days, as I said. The people who signed those nominating petitions also have rights. They deserve a right to nominate the person of their choice to be on the ballot. So they can choose to vote for that person or not. We are asking you to grant our motion to strike and dismiss. And by the way, that's what it is, a motion to strike and dismiss pursuant to your rules. If you look at your rules, that's what you call it, a motion to strike and dismiss. And even though we quoted a number of sections from the Code of Civil Procedure, we think correctly, it really it doesn't even merit talking about, because it's still a motion to strike and dismiss. We would just ask for a few minutes and reply, if we could, after council's done. I'm open for any questions if they want to now or save them. That would be.
I had one question
Yes,
for
sir.
you, and maybe you can address it. You talked about the signatures required, and you're arguing that the primary election should be the regular election that determines the number of signatures. Are you aware of any cases where that has been used in
No.
Illinois?
No, no. You know why? It's such a unique situation. I'm not aware of any cases where, there are circumstances that have happened where a county office holder or some other office holder resigns after the primary, and then either a vacancy is filled or not filled. But this is a very unique situation where the party, it seems to be an inner fight amongst the parties somehow. I'm not involved, I'm not from here, so I don't know. But it's a unique situation, and there are no cases. So,
Thank you.
Thank you.
Members of the board, council, thank you for your time today. You guys received a 16-page motion to strike and dismiss, and I want to be very, very clear associated with the reply that I placed on file that 80% of the motion that they placed on file is wholly irrelevant to what you as a board even has authority to decide. As I explained in my response, this frankly is limited to one isolated issue relative to the form of the petition itself, and it's strictly whether Mr. Rice set forth an interest statement in his petition. Council went on for nearly 10 minutes here relative to constitutional-based questions, constitutional-based arguments, raising questions as to why a detailed response wasn't placed in a reply to his motion. It's because the board does not have the authority to address and or decide constitutional-based questions here. The law is very clear on that, and actually counsel in his motion himself indicated that to the board. He is asking you to decide constitutional-based due process and equal protection questions in statutory construction, which the board does not have authority to do. This is a one isolated question for the board to decide, and it's whether Mr. Rice placed an interest-based statement in his petition. Simple. Associated with that one isolated question, I set forth a case for this board to read, Harn versus Evanston Municipal Officers Electoral Board. The court has made very, very, very clear the interest-based requirement associated with an objection does not require a caption, a bold-faced point for the board in any way, shape, or form. It is strictly, as this court had indicated, the interest aspect is merely a reporting requirement to the board. It's intended to apprise the board of the objector's interest in the ballot question under consideration. And in that specific case, the objectors on their petition stated their voter registration, that they were voters in the county, and that they were objecting to the referendum because it violated state law. That's what the objection indicated. There wasn't an interest statement in it. That was all in the content of the petition itself. The court indicated that satisfied the interest statement as noted. When you look at Mr. Rice's petition, he indicates he's a registered voter. He resides in Pontiac. He objects to the petition that's being filed. And that objection's being raised in two parts. Number one, this board in 2022 heard a very, very similar case of which a question was presented to this board as to whether there were satisfactory signature requirements presented to satisfy a sheriff's ballot. He wants the laws applied fairly. That's a very, very common interest to any voter in Livingston County. He raised questions as to dual circulators associated with the petition to uphold voter integrity in the county. Common interest. All of these things you as a board can look at to clearly discern the interest of Mr. Rice associated with the filing of the petition. And the courts indicated in the case that I just noted for you that an objector might merely be an opposing candidate, might be merely an opposing business, or it could strictly be a resident of the county and or a voter of the county. Counsel indicated he puts a mere blanket statement in his petitions. Yet you read Mr. Rice's petition, which is greatly more detailed than a blanket one-sentence interest statement provided by counsel associated with his petitions. This is clearly satisfied, associated with any type of motion to strike, because this clearly identifies for the board what's in front of it, provides framework for the board what Mr. Rice's interest is associated with this relative to election integrity within the county, permitting this to go forward. I'm hesitant too much due to just mere confusion, okay, with this, to get into much of the other worms with all of this, but I do want to make a couple points relative to some of the other arguments that counsel raised. Relative to whether you use a regular election for voter totals, okay, and or a primary election. Your assisted counsel just asked him, what case law do you have to support your theory? There isn't one. Okay? Regular election is clearly defined in the statute, okay? You are required through statutory construction to look at the statute and apply the words as they mean. Regular election is defined by the November results. Okay? The word primary election associated with the statutory section he's referencing, those words are not used anywhere, to be very clear. Okay? He's asking the board to amend the statute to his satisfaction to modify voter totals. Okay? His argument as to 10 days, all of that, it sounds really good, you know, you can be sympathetic to the argument. However, that's not what the statute says, and the board's required to follow the statute. It's very simple. So when you read that statute 10-3, you will never see primary election as a defining total. The county's already published the numbers. The numbers were provided to Mr. Tomkowitz associated with his application, and as he indicated, he believes he got 880 signatures. If that's the case, everything should be satisfied. The fact is, associated with the objection, the number of signatures are being questioned. And in 2024, associated with Mr. Baum's election, that's why we're here. Okay? So that's the purpose of the substantive hearing. Then, associated with his argument, he wants to indicate to the board, actually we only had 820 signatures. We're under the total because of the certificates of deletion. But please include the signatures that were on the certificate of deletion in my voter totals. Again, do you have case law to support it? No. Then why? Statutorily, clearly it indicates signatures on a certificate of deletion cannot be included in voter totals. I provided to the board what the word deletion means. Strike, erase, get rid of. The law indicates if it's deleted, it's gone prior to the date of submission. So he, under his own voluntary volition, indicates he did not satisfy the signature requirements before the board, which is why the arguments are attempted to be made. Then we get into due process and constitutional-based claims. And as I previously indicated, we can throw this stuff at the wall, they can attempt to throw this stuff at the wall, but you can't decide it. You don't have authority to decide it. So frankly, at this stage of the proceeding, doesn't matter. It's potentially going to matter at a later point in time. But he also forgets to indicate the election code actually has a completely separate section relative to this very issue at play, relative to timeframes, to fill vacancies for appointed officials, relative to timeframes. So he fails to identify, well, I guess until yesterday when he put in his statement of interest with the Republican Central Committee to be interviewed, which is going to be a separate related issue we'll have to address, but why he didn't proceed in that process. He's had full due process, full access to all the laws that everybody else has had, but he's trying to piecemeal and pick what is beneficial and what is not. But again, those are not issues for the board to decide. This is a very, very isolated issue, strictly as to whether the interest was identified. And that's all the board has to decide, frankly, relative to the motion to strike. The rest of it, in my opinion, can be tossed aside. It's not in the board's discretion or jurisdiction to hear, okay? And if you read the actual rules from the electoral board, specifically paragraph 9, I think it makes very clear that it's also in accordance with the administrative code. The electoral board will only consider the objections in the specifications of the objections. That's what it says. Not statutory construction, not constitutional arguments. So this needs to be dismissed in its entirety. This frankly needs to go to evidentiary hearing. We can figure out whether the voter totals were satisfied or not. The board can make those decisions. The other arguments being presented, you know, he makes the arguments as to COVID-19 and changing of voter amounts. Who made it? Federal court system. Not the board. Thank you.
Mr. Gerber?
Yeah, sorry.
Could you address the dual circulator argument? Mr. Odelson indicates that that statute does not apply because there was no state's attorney candidate in the primary.
So when you read the dual circulator statute, he's attempting specifically to dual circulation in that statute, okay, doesn't indicate that dual circulation applies candidate to candidate. Dual circulation applies in the general election as a whole to circulation for any candidates. So him attempting to limit this candidate to specific office is just not an accurate statement of fact. The case that he specifically cited for you in relation to potential scrutiny associated with dual circulation, when people do it for one public office, the same public office, I think is what he's talking about. But dual circulation, the statute is still valid. Okay? It's never been found unconstitutional. But he's trying to apply that in a very, very specific form on candidate to candidate, where dual circulation itself, the people that circulated the petition, it doesn't matter whether somebody voted for a state's attorney in an election cycle at all. So it doesn't matter whether a state's attorney was on that ballot for a petition for dual circulation to apply. Does that answer your question? Yeah.
Mr. Odelson?
Just a couple interesting points. This is the Illinois election code. Has all of the Illinois laws pertaining to elections. It's section 5/1-3 definitions. regular election means the general, comma, general primary, comma, consolidated and consolidated primary elections regularly scheduled in Article 2A. Because of all the confusion in prior years as to what you call an election, the General Assembly produced definitions for us. So a regular election could be the primary, could be the general election, could be the consolidated election. It is the regular election. Going backwards, in the 10-4 argument in regards to my application of 10-4, dual circulation not applying here, is incorrect. It's not my interpretation. As I read you the paragraph, that's the Illinois Supreme Court's interpretation found in this 2021 case, Elam versus Municipal Officers Electoral Board for the Village of Riverdale. I'm sorry, Elam, E-L-A-M, versus Municipal Officers Electoral Board for the Village of Riverdale. The Supreme Court interpreted it. That's not me, that's them. The certificate of deletions argument, the Lezak case I cited, and the law says if you want to not count a signature, you have to file a revocation prior to you filing your petitions. You have to revoke the petition, the signature. Although the way we have structured this case and argued this case, if the motion to strike and dismiss is granted, that does not become an issue. The interest of the objector. I too have read the Howard case. I referred to it. Did a little more work on it after I read the response. Case was based on. And if you look at the first paragraph, just the first paragraph, we, the undersigned Evanston residents and registered voters, object to the Evanston voter initiative because they're giving a reason. They're stating their interest. It presents a binding referendum question in violation of state law, and the question presented in the petition will confuse the voters. That's what the Howard case had before them, the interest of these residents and registered voters. The interest being the binding referendum violates state law, and it will confuse the voters. So the voters here, the petitioners against the referendum, did state an interest. You can't, again, I'm repeating myself a bit, but it's so important. You can't piece together an interest like you can't piece together a voter's address or his registration status or his name. If he had put down, I'm David and I reside here and I live in Pontiac, not sufficient because he didn't state his full name. You can't piece together an interest. You have to have the interest. Again, no specific language of what your interest is. The law doesn't require that, but it's a mandatory requirement of the election code because we're talking about access to the ballot. And the General Assembly and the courts have very clearly said, we're going to make it hard to object because people deserve to be on the ballot. It's really, it all boils down to that. So again, we would ask that you grant the motion to strike the objector's petition and allow access to the ballot to the state's attorney. Thank you.
Mr. Odelson, I have one follow-up question.
Sure.
With regard to interest, Mr. Gerber argued that the objection stated an interest in seeing that the petition complies with law and that voter integrity be upheld with regard to dual circulators. Did you see that in his objection, or do you have a
No.
response to that?
Yes, I don't find it in his objection. Mr. Rice's objection, under the title eligibility of petitioner to object, he carefully lists his name, his address, that he objects, and he's asking for release. He's asking for this board to take the state's attorney off the ballot. He's asking for relief. He's not stating what his interest is. So, as I said in the beginning, he complied with 4 out of the 5, but you have to comply with all of them when ballot access hangs in the balance. Thank you.
Well, moving forward, we'll take your arguments under advisement and then make a determination. We could, in the meantime, while we're waiting for the appointment of the third person and a decision on these matters, we could move forward with an examination of the records. I'm not sure if the parties would want to do that. You want to provide some recommendation to the board?
I don't want to waste the board's time or the county clerk's time. The numbers are the numbers. They don't attack individual lines as far as signatures. They attack certain circulators based on the legal argument. And if that legal argument fails and 837 is the number, then that would bring the candidate below the minimum. So there's no, it's typical in many of these objection cases, they object to a line is not registered or not, we don't have that here. So I don't think, it's my opinion, a record exam would be meaningless at this point.
Gerber?
I was hoping that's what council would say. I haven't had a chance to discuss that with him, but I mean, if that's their issue, I mean, we're dealing with legal-based questions. So that's why I indicated, to the board, I think this is an isolated question. And I think that, frankly, the court system is going to make the rest of the determination.
My recommendation then would be to recess the board until we get a third appointment, and they've had an opportunity to review the record, and then we can reconvene and issue a decision on the motions.
Process moves fairly quickly. The clerk knows that ballots come very quickly in early voting, and depending on who wins or loses, we'll probably want to go to the next level and then the next level. So, again, speed is always important in election cases for both sides.
We'll try to get the third member appointed promptly. A little of that may be out of our control, or the board's control.
So, are we done then? What we need right now? Yep. Okay. The board will recess until such time that I call the electoral board to reconvene. Motion to recess by,
I'll motion to recess.
and I will second that. Meeting recessed at, what is it, 1:10? 2:10. Okay. Thank you all for coming.
Thank you.